This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with the Hon Marcia Neave AO. Marcia began her legal career as an academic and is known to generations of law students as both an exceptional teacher and the co-author of the seminal textbook Sackville and Neave Australian Property Law, now in its 12th edition. She was also the first academic to become a Supreme Court Justice of Victoria, sitting on the bench from 2006 to 2015. But Marcia is perhaps best known for her work in law reform. In the 80s, she led the inquiry that resulted in the decriminalisation of prostitution in Victoria. Later, she was the foundation chair of the Victorian Law Reform Commission, which, amongst other things, recommended substantial changes to criminal laws and procedures dealing with sexual assault. She was a commissioner in the Royal Commission into Family Violence and currently sits on the Australian Law Reform Commission. As is evidence from the extraordinary impact she has had on our legal system, Marcia tends to view the law and law reform through the lens of gender. Whether it be at the highest positions in our society or in the front bar of a uni pub in Carlton, Marcia has no fear taking a stand and shining a light on inequality.
And what about Norton's Hotel, which was across the road from the university? You became notorious there.
I don't know that I was notorious, but I had a nice group of friends, men and women, and we used to go there for a drink. And for a little while we went to the public bar, and then they suddenly decided that it wasn't appropriate. And I think I was the only woman there that day that wasn't appropriate to have me, a woman, in the public bar. So they told me I had to leave. And I was very grateful to my friends because they all walked out with me.
And of course, in those days, hotels had another area called a ladies' lounge.
They did.
And that's where the ladies were meant to be.
And they suggested that I go to the ladies' lounge, and I said, why can't I stay here? What's the difference? But they wouldn't let me stay.
Our guest this morning in Lives in the Law is the Hon Marcia Neave AO. Among her many roles in a long life in the law, Marcia is a former appellate justice of the Supreme Court of Victoria. But as I have said, there are many roles which we will hear about in our discussion with Marcia. Marcia, good morning.
Good morning, Michael.
Marcia, in reading about your life, I was surprised to read that you were born with club feet and you wore calipers until you were 11 years of age. Do you think that had a significant effect upon your development and who you are today as a person?
Yes, I think it shaped my personality in a number of ways. Who knows how much is environment and how much is genes, but I think it did shape my personality. One of the things I think it gave me was some empathy or appreciation for people who are a little bit different or who were perceived as disadvantaged. And so I remember standing up for people who I thought were being unjustly treated when I was quite young. I spent quite a lot of time in hospital as a child, and I remember on a number of occasions I would have a bit of a battle with someone because I thought they weren't treating another child kindly or fairly. So I think that was important. And the other thing I think it did, I was an argumentative person, and I think I believed in the power of rationality and persuasion. And so I would try to explain to people why what they were doing was unfair or inappropriate. And obviously, as a youngish child, this was intensely irritating for other people. I didn't like it very much. And finally, I think, and this was due to the way my parents treated me, and in good ways, is I don't think having a physical disability stopped me from trying to do things. I sort of ran in the school sports and did all of those things. I was shockingly bad at it, but I did all of those things.
The calipers came off when you were about 11, but I'm assuming, was that because your feet had changed into a normal sort of a configuration, or was an operation necessary?
I had lots of operations all throughout my childhood. And finally, my father was a surgeon, and there was no one in Australia who could fix my feet, basically. and he corresponded with a surgeon in England, and I was very fortunate that my parents could afford to do this. So they sent me to England with my mother for an operation which at that stage was quite unusual and I think was in all the medical textbooks, and it fixed, my feet are not very pretty to look at, but it meant that they no longer turned in and I didn't have a crippled walk. I've met other people of my age who didn't have that surgery, and some of them are really quite badly, all their lives have been quite badly disabled. I mean, club feet can be quite minor and you can fix them with minor manipulation, or they can be quite major, and they were in my case.
And so how long were you away in London with your mum?
Well, I was in hospital in England for 6 months, because I had to do one foot and then I had to wait and they had to do the other foot. So I actually was in a children's ward in a hospital in Surrey for 6 months.
And what about schoolwork during that time? Were you doing English schoolwork, or were you seconded to an English primary school? Or?
No, they had a little school in the hospital, interestingly, but because I was a little bit older, I was sort of 11 turning 12, I missed my first year 7 at school, really. And so they'd sent me with a whole lot of work, including things like having to knit a jumper or knit socks, other things like that. And so I took that and I did as much of it as I could. I think it disadvantaged me in terms of maths because I missed that progression that you get in terms of learning maths, which is a progressive subject. I read widely. There was a library in the hospital because a lot of the people in the hospital were long stay, and I was a girl guide in the hospital, believe it or not.
It's interesting you say you think you might have missed out in some of the basis for mathematical subjects. You come from a medical family. Your dad, your grandfather are doctors, and your dad wanted you to be a doctor.
Yes.
But you didn't, get the marks in the science subjects or something like that?
Well, I went to year 11 and I did all right in year 11, and I was doing physics and chemistry and maths and things, but I wasn't as good at those subjects as I was at English. And so I sort of made the decision. My father was very disappointed because he'd been taking me into hospital to watch operations since I was about 6. He was very disappointed, but I then decided, and I didn't decide to do law. I thought I'd do an arts degree, but my mother encouraged me to do law.
And so you're doing law starting in the early 60s, 1960s, very different to a law school today, I'm sure. What was it like doing law in the 1960s, particularly as a woman, I guess?
Well, I mean, I thought I loved my law degree. I loved my education. I loved university. On the other hand, a lot of the things that I now understand about the law were not exposed to me. I didn't understand. I mean, I really believed, I think at that time, that if you treated men and women exactly the same, then you would end up with equality. And I didn't have the sophistication or the exposure to the ideas that we now have and we now understand about how if people are differently situated and you treat them the same, they will end up with inequality. And I think also there were lots of areas of the law which at that stage were really pretty in need of reform, and we didn't really have much discussion about those sorts of issues at all. And there were laws that clearly discriminated against women at that time. So, for example, when we were discussing sexual offences in criminal law, we did a case which said you had to resist, you had to fight, and if you just waited or thought, I better not resist because something terrible might happen to me, then you couldn't be found, the defendant couldn't be found guilty of rape. And I remember in the criminal law class vividly trying to raise this and say, but that's not fair. I mean, this is completely inappropriate. She might have been terrified. And there was a gale of laughter. And I have to say the lecturer at that time did not intervene to protect me. I just put up with it. And I wasn't scarred by it, but I remember that moment quite well.
Yes, you make me think, being at university in the 60s, same as you, only a bit behind you, I don't remember any discussions about areas of the law that maybe should be changed.
No, there weren't.
We just learnt what was the existing law was and how it had developed through the common law system, basically, but there was no discussion about how we could do things better or improve things.
I think that's probably true. I mean, but the sort of whole body of scholarship now about how the law affects, and it's not just about gender, it's about disability, it's about race, all of those differences, how the law impacts differently on people from in different contexts, Indigenous people, for example.
But overall, you enjoyed your time at university and studying law, and it made sense to you.
Yes, I liked, because I've always been a believer in rational argument, I liked the sort of logical processes. I mean, I did quite well at school in my final year at school, but not exceptionally. And then in first year law, I think I came top in every subject except one. So that was sort of, to my amazement, this is something that I got and understood and really liked. And a lot of people take a long time to get to that state of mind. It just suited the way I thought, I think. So I was surprised that I'd done so well, and it meant that I, wanted to go on, clearly.
And without being overly modest, you maintained that standard until your final year.
Yes, yeah,
I did. And won the Supreme Court prize.
Yeah, I did do well, and it was, a lot of it was about the way I was taught. But I also had a great little study group of friends, many of whom have gone on to do other interesting things, and we all supported each other, and we enjoyed that process of studying together.
You do articles like everyone did in those days at a small city firm. Mm-hmm. Were articles hard to get, particularly for a woman?
Very hard to get, and in fact, the only reason I got my articles was that my father had died by then, and the family solicitor had said to me, "Oh, I'll see if I can get you articles." He was a sort of a little one-person firm, really, and the response was always, "Oh, we don't have any women's toilets." And I used to say, "Well, you've got all these secretaries. Where do they go?" So anyway, it was a good, small, medium-sized firm, and I was the first woman article clerk they'd had, and that was sort of interesting in all kinds of ways.
Well, now, we'll tell our listeners, because most of our listeners wouldn't be aware of such things. You received a living wage, of course, enough to support yourself on. How much was that wage as an article clerk?
No, actually, it was about $9 a week, but I was, by that time, was I married? I can't remember. No, I wasn't married. Yeah, it was about $9 a week. And, there was no award. That came much later. There was no award for article clerks. So I was frugal, and I always have been.
You were the only woman in the firm, apart from the support staff?
Yes.
How did that play out, say, at...
Well, I don't think, at that time, I think the young women who were what we used to call secretaries or typists, they hadn't ever worked with a young woman who'd done law, and they weren't awfully nice to me at that time. I think they thought, maybe I was giving myself airs or something. So they didn't tell me things that they knew. I mean, they knew perfectly well how to prepare documents and so on. And I didn't do much litigation. I did a lot of document preparation. It was a time when, believe it or not, the rules of superannuation were being changed. And so I was doing things like redrafting superannuation deeds, which was not actually very gripping. On the other hand, there was a woman conveyancing clerk there who was very helpful and supportive. And the guys who were article clerks were helpful and supportive too. So, I didn't have a miserable time, but I wasn't gripped by it.
And what about at the end of your articles, or maybe the end of your articles, comes Christmas time. Christmas, I guess there's a break-up Christmas dinner for everyone.
Yes, there is.
And all the firm comes together as a one unit and has...
Well, in those days, the partners and the male article clerks used to all be taken out to dinner, and I understand there was a bit of a kerfuffle because they didn't think it was really appropriate to take me as the only woman with all of the men, and they weren't quite sure what to do with me. So in the end, they decided I should go out to dinner with the secretaries, and so I went out to dinner with them, and that was sort of supposed to be appropriate, I think.
Looking back, they're strange times, but it wasn't strange at that time.
No, it wasn't at all strange. And I have to say, people were kind to me and supportive while I was doing my articles. It was just that I was a bit different and they didn't quite know how to handle me.
After your articles, you do not continue on in private practice. You accept a position as a tutor back at Melbourne University. Did you consider staying on in private practice?
I think I thought it would be difficult. I was married at the end of my articles. I thought it would be difficult to combine practice with having children. But also, I I didn't find what I had done in articles as interesting. I mean, I learnt a lot about, how you behave in that sort of a setting, but I didn't find it as interesting as having been at the law school. And I was approached by Zelman Cowan, who was very good at tapping the shoulder of women who had done well during their course and saying, would you like to come and work as a tutor for a few years? And the basic understanding then was, this wasn't a career path. This was something that you would do, and then you'd go off and look after your children full time. But I had a role model. I had a friend who had a child quite young, and she sort of decided to stay on. And so I thought, well, I can do it too. So I decided that I would, when I was given the chance, that I would stay on. So I was a tutor for 3 years with a number of other people who went on to have very interesting legal careers. Then I was offered a lectureship. This was quite funny because it was a lectureship named after somebody who became a corporate criminal. So that was a 1-year lectureship, I think. And by then, people knew me and things opened up over time. So I was lucky.
One of the things I've observed throughout my working life is that teaching is a particular skill of its own, and not everyone's got it.
Yes, I agree with that.
Did they give you teacher training?
Not very much. There was a little attempt to do it. And as a group of tutors, we used to talk about things. We taught a course called legal writing, believe it or not. And that meant we had to sort of design materials and get together. So we talked about it in that context. And we did have somebody from the education faculty who gave us a couple of classes. But I had 3 younger brothers, and I always used to teach them things. And I really liked teaching, and I liked that interaction with students. Most of the students weren't much younger than I was, but I really enjoyed that. And then later on, when I became a lecturer, I taught Ron Sackville, who later became Justice Sackville of the Federal Court. He and I taught property law together, and we used to go to each other's classes and critique each other and sometimes ask questions in the class, if we thought something wasn't clear. These were smallish classes, and that was a great way of we interacted, and he was a good teacher.
Socratic.
It was Socratic. It was nearly all Socratic, which was great.
That's excellent, isn't it? Did you have an affinity for any particular subject or subjects, plural?
Well, initially I liked 2 things. I did not want to teach subjects that had traditionally been assigned to women, like family law. I wasn't interested in that. I did like property law and equity, and I particularly liked equity. Professor Harold Ford was the dean and taught equity, and because the classes were small at that stage, I taught one group and he taught another group. Maybe there were probably more than one group. And so I interacted with him a lot. I think I used to probably drive him crazy because I'd run down to his office and say, but what about this and what about that? But it was a very good experience, having been taught by them and then working out what I wanted to do and how I wanted to do it.
As an academic, Marcia, you also did a significant amount of writing.
Yes, I did.
And I think, is that almost obligatory for academics to...
Absolutely, yeah.
To publish.
And particularly now, more so than then, but even then you're expected to publish. Now there is an expectation that you'll publish 1 or 2 articles in refereed journals a year at least, and there's a heavier teaching load than we had. Now, I think things have gone backwards in universities. So it is an expected thing, and the very first article I wrote, which was quite boring, was about regulation of the production of oil and gas.
It doesn't sound riveting much.
It was not riveting. It was not riveting. But then the first thing that I remember really enjoying writing was about the abolition of the status of illegitimacy.
Oh, yeah.
In Victoria.
And where was that published?
I think it might have been published in the Melbourne University Law Review. But the thing that was interesting to me about it was that I decided, well, you can look at the bill, because it wasn't an act at that point. You look at the bill, comment on the bill. But I was very interested in learning about the problems that single mothers had, because in those days there was no Commonwealth pension. You could get a pension if you were a widow or a deserted wife, but you got some support from the state if you were a single mother with a child. And so I wanted to talk to some people who'd been through this And there was a body which had just been created called the Council for Single Mother and Her Child. The chair was a woman called Tricia Harper. So I thought, I've got to find out what it's like, how do people deal with all of these difficulties that they're likely to experience? Things like there are all sorts of difficulties in obtaining maintenance from the father, there are all kinds of restrictions. So I talked to her, and that influenced the way I wrote that article. And I think that from then on, I always wanted to put my feet on the ground and think about the practical implications of the law. So that would have been the first article that I wrote that I really enjoyed and thought I'm doing something important here. And other people were writing about issues like, for instance, the whole problem of maintenance. I mean, there was a rule in maintenance that if you'd had intercourse with any other man around about the same time, then you couldn't recover maintenance from the person, even if it was very clear that he was the father of the child. I mean, now you'd have DNA tests and things, but even if in those days they had some tests, even in that case, if you were not chaste, except for the person who was the father of the child, then you weren't entitled to recover maintenance.
And chastity was not a requirement for the male?
No, absolutely not.
So, as well as those articles that you were publishing, you also wrote a seminal, or co-wrote a seminal textbook on property law.
I did, and Ron Sackville and I taught property law together and interacted a lot. And so he suggested we wrote this book together, and it was a new sort of book, property book. It wasn't just about real property, it was about concepts of property and things like who has property in a body? Do you have property in your organs? Or a whole series of really novel questions and issues. Didn't deal with intellectual property, but it dealt with a lot of different forms of both personal and real property. And it was probably, I think, the first book that focused a lot on the Torrens system and the Australian systems of property law, rather than, as I was taught, just really a lot of legal history about English land law with a fairly brief mention of, the fact that we had a Torrens system. So it was much more Australian focused. So that was great, and we wrote that, and I think we did something like 4 editions together, and then I think it might be up to about its 12th edition now.
And someone else is doing it? Someone else is updating it?
Yeah, various people have moved in and out of it, but I moved on to other things, so I couldn't keep doing it. And goodness me, it's up on the shelf up there.
In the early 80s, when you've been an academic at Melbourne Uni, and I think still an academic at Melbourne Uni, you take a position as Research Director of the New South Wales Law Reform Commission.
Yes.
Did you? This was on secondment from the university?
Yes.
And how did they know about Marcia Neave to offer the position?
Ron was at that point, and he was an academic for many years, and I think he was Dean of University of New South Wales Law School. And he then chaired the New South Wales Law Reform Commission, and they advertised a job, and I was sort of feeling I'd been doing what I'd been doing for quite a long time, and I wanted a change. And I investigated a few jobs in Victoria, but then applied for a job at New South Wales and got one.
And you commuted to Sydney on a weekly basis?
I did. My children were quite young then, and I'm very grateful to my former husband because he had the children. He looked after the children during the week. We had some help, but I'd go up leave home at about 5 o'clock on Monday morning and come back late afternoon on Friday.
Which is not that uncommon nowadays, but it would have been uncommon then, I think.
Yeah, it was. And Ron was everyone was very supportive and helpful. And it was a wonderful learning experience for me because I was learning the art and practice of law reform and inventing bits of it, I think, too. I think it was really enjoyable.
What might you have invented?
Oh, I think we developed the whole process of community consultation. New South Wales had been doing that, but we sort of developed it in the projects on which we worked. So we had a number of projects, big projects, very ambitious projects at that time, and we did a lot of community consultation. We did a lot of work on social science research as much as you could in those days. We commissioned people to do various things for us. And so I was overseeing that process, of course, with the commissioners guiding me. So I was doing that work in areas, for example, of what used to be called de facto relationships and no-fault accident compensation were the two main areas, but I worked on a number of other areas as well.
what was the outcome with de facto relationships to start with?
Well, that was about both division of property and maintenance for people who are living together. And there was serious injustice in that area because a couple could have been living together for 20, 30 years and they separate and the property's all in the man's name. So the woman was at that time entitled to nothing. Now, equity, I'd got into this because I was interested in possible equitable remedies, and there was a little bit of High Court authority which you could build on, but it didn't go far enough. And it didn't deal with issues like maintenance and all of those other issues. So we, in the end, recommended a regime under which property could be divided based on contributions and needs, a bit like the Family Law Act, between a couple who'd been living together. And at that time, of course, that was done by state courts, not by the family court. And then I remember thinking at the time, why are we confining this to heterosexual couples? Because there was case law about injustice in situations where you had two men or two women living together and the same injustice arose. They could have been around together for a very long time. They could have been making contributions, but you couldn't. There was no opportunity to divide the property except in very limited circumstances.
And everything was in favour of the person in whose name the property was owned.
Exactly. And the equitable principles were quite limited. You had to show basically a common intention, and that wasn't easy to show. So anyway, the legislation was passed in New South Wales. I think we did some good work around getting the mainstream churches on side because some churches were very concerned that this would sort of degrade marriage. So the argument that we were making was to them was, well, this is about injustice. Are you really saying that it's fair in these circumstances for people to be left? You know, they've worked on the farm, classic example, they've worked on the farm for 30 years and now they're out and they've got nothing. And the person in whose name the farm was gets it all. Is that fair? So anyway, we got some support. That was adopted in New South Wales. Other states followed suit. And now, of course, it's broader than simply couples who are in heterosexual relationships. It can cover all sorts of other relationships as well. So that was an important piece of work. And the no-fault accident compensation work was important too, because at that time we were looking at a proposal for a New South Wales system of no-fault compensation based on the New Zealand system. Enormous opposition from lawyers. I remember coming down here and having to have a debate with a prominent member. It was some educational thing that I was asked to speak at to the Victorian Bar and being given a really hard time by a very prominent Melbourne barrister about how shocking this would be. That was good.
I assume it's a he.
Yes, it was.
And he wasn't speaking through his pocket.
No, of course not. How could you suggest that? But, I mean, the lawyers were opposed to that. The economists, I think we had an economists commissioner. We certainly consulted with economists who kept saying, well, there's all this money that's going into the legal system which could be used to benefit people. And I have a vivid memory, because we did lots of interviews of people who had serious injuries. We had a questionnaire and a sort of an interview process. And I remember going out to the Royal North Shore Hospital in New South Wales, and there were, in the spinal unit, there were 3 people. You know, one of them was going to get a couple of $1 million. One of them was going to get nothing. And I can't remember what the third, but they were all in very, that's right, one of them was going to get some workers' compensation. So the amount they got had nothing to do with their needs or their injury, depended solely on the circumstances in which they'd been injured. So we talked to actuaries. We did lots of really interesting work in this area.
But it never got off the ground?
Never got off the ground, although I believe it had some influence. And a lot of the thinking we did, because we had to work out what the compensation scheme would look like, not just the issues of who was entitled to it, but what the scheme would look like and how it would deal with, for example, people who weren't earning, i.e. women. What would you do in that situation? So I think some of the thinking on that was picked up later in some of the no-fault schemes. Professor Harold Luntz, who was a professor at Melbourne Law School, he was a fervent advocate of no-fault compensation for a very, very long time. And he was one of the people that we talked to across Australia. So it was a good project, and it was a bit sad that it didn't happen.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
Marcia, soon after you finish your time with the New South Wales Law Reform Commission, you're heading up the Victorian inquiry into prostitution.
Yes.
Are you still at Melbourne Uni on secondment, or have you resigned from the uni?
No, I was still there at that point.
And how did it come about that you are heading up a Victorian inquiry into prostitution?
Well, there were some issues about prostitution in Victoria. There were concerns about corruption. There were issues about where brothels were and people complaining that if they were in a street in some suburb, somebody'd come and knock on their door looking for the brothel, and they were, in any case, illegal. So the Kane government was concerned about what would they do about this. And it so happened that one of the attorney's advisors was somebody whom I think I had actually taught at Melbourne Law School. So he approached me and said, I was looking for policy work because I really liked policy work, and I don't know how I made that known. I don't remember, but he contacted me and said, "Would you be interested?" And I said, "Oh yeah, I'd be very interested." So it took a year, and I used the things that I'd learnt. I had a couple of research officers. I took the things that I learnt at New South Wales and tried to use those methods to investigate the issue, as well as all the conventional research, and I haven't even mentioned that, but, a lot had been written about this issue. And we had a questionnaire. We interviewed large numbers of sex workers. I went and visited a number of brothels, which was quite funny because I'd just knock on the door and say, "Can I come in and talk to people?" which I did. And so we came up with our recommendations, which took some time to be implemented because I think the problem was at the time the government didn't have a majority in the upper house, but eventually nearly all the recommendations were implemented. I probably would have gone, looking back, might have gone a bit further, but I think what we did was acceptable at the time.
And didn't someone say to you previously that you have to walk before you can run?
Oh, yes. That was a comment that Ron Sackville made to me when I said, why were we just looking at heterosexual couples? We should be looking at gay couples as well. And he looked at me over his spectacles and said, "You have to walk before you can run, Marcia."
And that may have been the case with your recommendations.
Yeah, he was right. He was right, because what happened was what I thought should happen happened eventually when people realised that civilisation as we know it did not fail as a result of creating justice for women who'd been in relationships with men who owned the property. And I think people sort of got their head around that then, and so it was much less difficult. But anyway, in the context of prostitution, we obviously had to talk to police. We had to talk to councils because they had the planning control issue. We talked to medicos because some of this was happening at the beginning of the HIV/AIDS epidemic, and pulled together a set of recommendations which, as I said, ultimately became the law. So prostitution, except on the street prostitution, was decriminalised. That is, a person couldn't be subjected to criminal punishment because they were a sex worker. And there were processes for control of location of brothels and for licensing of brothel operators. And I liked a vision of what I used to call cottage industry prostitution, which is if you had a couple of people working together as sex workers. So you didn't really want to encourage women to work alone because they were at risk. If you had a couple of women working together, then they shouldn't have to go through the planning control process that you had to if you had a bigger brothel, which clearly was going to be disruptive for the neighbourhood.
You've made the comment that in conducting an inquiry like this and seeking to change the law in a situation such as this with prostitution, it's very important to educate people about what you're proposing.
Yes.
We, the community.
Yes. I agree with that completely.
Why is that, and how do you do it?
Well, I actually think that you have to prepare people to think about things in a different way, because the submission, every inquiry I've conducted, you call for submissions, you may have hearings in the case of a Royal Commission. People come with a view, and that's very, very helpful. But there's a great mass of the public out there who haven't really thought about these issues and can be made to experience concern. It can be sort of whipped up into a frenzy about concerns which are not necessarily based on any reality at all and not based on any sort of data or information. So I thought it was important to go around and talk to people about possibilities and what the issues were. So just as an odd example, when I was doing the prostitution inquiry, I talked to lots of women's groups and heard their views. I went and talked to Rotary clubs and heard their views as part of this sort of education process. Now, it's a luxury, but I think there's less discussion now on policy in the mainstream media. You very rarely see a discussion about the pros and cons. And for complex problems, you'll never get it completely right. There'll always be some pros and cons, and you have to make a judgment call on those issues. And one way to get people to think about that is to talk to them and to hear what they have to say. So that's something that, as much as you can do, I think you should. And particularly in the case of law reform commissions, they've got the opportunity to do that. And of course, you know, you have formal consultations as well. You talk to all of the people who've got an interest in the area or who know something about the area. You commission information. You get people to collect information, data, statistics, all of that sort of thing, as much as you can. It's a bit harder with a Royal Commission to do that. I mean, I'm leaping ahead a bit, but with commissions, you've got to be a bit careful that you don't sort of set hairs running about what you're going to recommend. Whereas with this, you could sort of say, well, look, you know, this is the problem. There are various ways of solving it. You could do this, you could do that. These are some of the advantages of this. These are some of the advantages of that. These are some of the downsides. And I think that prepares people. I think it's a useful way of getting people to think about the issues. And they certainly don't. I mean, at the moment, everything is so polarised in social policy. I mean, with social media, you get people posting things about how this will be a disaster and people saying it's the only thing you can possibly do. And usually the truth is somewhere in the middle there.
It seems to me to be very difficult in that situation with social media to actually get some common ground, which
it is.
We as a community can.
It is. It is. And of course, I was doing the prostitution inquiry before the advent of social media. But, you know, law reform commissions also have these techniques. They put out issues papers. They provide information in a variety of ways. So there's conventional techniques. I didn't invent them, but you could adapt them and use them.
You've said that the outcome of the inquiry into prostitution was to prioritise harm reduction,
yes,
as opposed to criminalisation.
Yes, that's right.
I have wondered over the years whether that aim, prioritising harm reduction over criminalisation, could be applied to the drug problem we have as a society.
Well, I think you'd have to think very carefully whether it applied to all drugs. For example, you'd have to think about the processes where people get access, but I think there's a number of arguments in favour of that. And if you go back, I mean, before we had the American war on drugs, that tended to be, was certainly the approach in England with drugs like heroin. You get a prescription. It's more complex now because we've got these vast criminal empires which are making a lot of money out of drugs. But whenever you have prohibited things that people want to do, you create the possibility of black markets and huge amounts of money being made. People have been writing about this. There was a book I read probably 40 years ago called An Honest Politician's Guide to Crime Control, which was all about the costs of criminalisation of things that probably only harm the individual in most cases and have where criminalisation has enormous side effects.
Could I say, Marcia, moving on, that you tend to get around?
Yes.
Because next time we see you, when I say next time, this is flowing on, you are the John Bray Professor of Law at Adelaide Law School.
Yes.
And then you become Dean of the Adelaide Law School. How did that happen?
Well,
you must have left Melbourne Uni.
Yes, I left Melbourne Uni. I applied, and I think I was encouraged to apply by Professor James Crawford, who's now sadly dead, but who went on to have an amazing international career. And I think probably got an advantage at that time by being a woman, because there was only one woman professor in the Adelaide University. So they were trying to find somebody who would be appropriate. So I went through the normal, obviously, competitive process of being interviewed and so on, and there were several internal candidates for that job. And I got it. I didn't really want to be dean very much, but I was sort of lent on to take that on because I really liked doing the writing and the thinking probably more than the managing of people.
Are you good at managing people?
Oh, you'd have to ask someone else. I don't think I'm too bad. Academics are hard people to manage. I think lawyers are hard people to manage, and they always have virtue on their side. You know? They always think they have virtue on their side. And there were some issues about the law school that needed to be addressed. So I, worked on some of those. But one of the other things that happened when I was at Adelaide, which I liked very much, was there were a lot of women mainly doing very interesting work in other disciplines. And because the university was smaller than I had been accustomed to, I got to know a lot of these women. And I got to know people like Dame Roma, who I'd met before, the woman who was the Vice-Chancellor of Flinders University. So there were a group of sort of supportive women, and a lot of them doing very, very interesting work, thinking about how their discipline reflected or didn't reflect issues about women. And I was reading, there was already people writing really good legal stuff. Reg Graycar, for example, wrote a book about gender in the law, I'll forget someone. So, but there was already some good work, but it was still not part of the mainstream. So I sort of said to the women lecturers in the law school, not just the women, anyone could come, I'm going to start this feminist theory reading group. So let's get together and talk about these ideas and see what we agree with, and let's involve some of the people who came from other disciplines. Very interesting. In the area of science, for example, most scientific experiments testing things were done only on men. And there were reasons for that. There were concern that women might be affected if they were pregnant, etc., etc. But it meant that the data that you had didn't take account of women's...
Half the population.
Yeah, that's right. And then in areas such as history, what counts as history? So there were people at Adelaide, I could name lots of them, who were doing this sort of work that I really enjoyed talking to, and they didn't know much about the law. So there was a sort of a nice exchange of ideas.
Were you teaching at the same time?
Yes, I was. Yeah, I don't think I had a reduced teaching load.
So this really was something which interested you and you thought was important.
Yes.
And so you incorporated it into...
That's right, I did.
...part of what you were doing.
And I probably and would have incorporated it into my teaching. And, for example, there was... and I know that other people started to do that. So, for instance, in the area of evidence law, people started to look at the way evidence rules work in certain sorts of cases. And, that came out of our discussions in feminist legal theory.
And in setting up, you helped set up the Flinders Law School in South Australia.
Yeah, I was on the committee that sort of came up with a curriculum for the new Flinders Law School, which was more radical than the way we did it at Adelaide, and did a whole lot of things that I would have liked if I had a complete open hand the way I would teach law. And I'm not sure how much of that got through, but certainly, and I recruited some people from other parts of Australia, and we all got together and came up with a proposed curriculum.
And after 5 years in Adelaide, I'm assuming Monash came and headhunted you.
My husband he'd had various jobs, and so he went back to Melbourne at that time. And so I think I wrote to them and I said, would you have anything, if I came back? And there's this possibility of having a personal chair. So that's how it happened.
And it was a personal chair in what?
Just in law, just a personal chair. It didn't have a topic.
Yeah.
It didn't have a name like the John Bray Professor of Law.
Yeah.
It was just just come and be a professor at Monash. And then I went there and taught what they wanted me to teach, and I ended up teaching, I think I taught torts, I taught some property, and I also taught some family law for the first time, I think.
It also included being acting dean at some stage?
Yes, it did.
And associate dean?
Yes, the acting dean job was, and I certainly, that wasn't something that I wanted to do. I didn't want to be dean. And so when the dean went, I sort of held the fort until we got a new dean.
So you're at Monash for 5 years. Then you become, in 2001, the foundation chair of the Victorian Law Reform Commission.
Yes.
Am I thinking that wasn't a full-time position?
No, it was full-time.
That was a full-time position?
And I got seconded, initially I got seconded from Monash to do that. And I applied for that job, relying in part on, what I'd already done, like New South Wales and the prostitution inquiry. And I was lucky enough to be appointed as chair, and it was wonderful. I had been on the old Law Reform Commission of Victoria, which had been abolished by Kennett as a commissioner a long time ago. But this was a new body, and we got some exciting references, and I wrote in and made some suggestions about their legislation when they published their bill, and then I applied for the job and I got that.
So when you say exciting references, the issues which the Commission considered and made recommendations on, I assume, were things referred to you by the government of the day?
They were, but I made some suggestions about things that we should be looking at, and unfortunately Jim Kennan was prepared to give us those references. The other thing we had in that legislation, and I did suggest this, was what we call community law reform. So people could write in with a small issue and we could do it quickly. And it was often just a little tidying up thing. The most successful one, this is funny, was somebody wrote in and said they don't make water available in nightclubs, which is dangerous, because if people are taking drugs and they're not, you have to buy a drink. You can't. I think the taps were hot water or something. Anyway, it was hard to get drinks. And I think it was a student, and I said, well, why don't you write us a little paper on this, and we'll fix it up and we might publish it. Anyway, in the meantime, the health department got to know that and made them do it. So this was instant implementation.
It was compulsory to provide water, yeah, free water,
to make sure that you could use the bathroom to get water.
Yeah, okay.
Yeah. That was a small thing, but there were lots of other little things that we did like that. We particularly asked for defences to homicide.
So that was something which you actually initiated. You said
the government gave it to us, but I thought it was an area that we should be looking at. And it was sort of related to violence against women, obviously. Evidence law, which I didn't work closely on, that was worked on by...
So can I go back to defences to homicide?
Yes.
So what was...
Well, a number
there are
of
many
issues.
defences.
A number of issues. One was that women didn't usually argue self-defence because of the circumstances in which women were murdered, and they tended not to. I often did a plea deal and pleaded to manslaughter. So instead of having the possibility of a complete acquittal, they didn't, because that was the advice they were given, and it wasn't bad advice at the time, but that was because of the way that the offence was formulated. But the other, and that this was more controversial, and this is something I changed my mind on over time, was provocation, because provocation reduces murder to manslaughter. But when you looked at who relied on provocation, it was men who came home and thought their wives had been unfaithful to them. They were best off if they could have come home and found the woman with the guy, but that wasn't a requirement. And there was one particularly appalling case about that issue where the man he got a manslaughter. And
simply because he said, I thought my wife was having an affair with him.
He said she'd confessed it to him, or she told him she wasn't coming back and she was going off. So again, it was the law operated in a way that meant, not many women murder men. Many more men murder women, and they often murdered them in circumstances. Well, you will have seen all of these dreadful figures about family violence at the moment. But very often in these circumstances, women defended themselves. And see, if you're not as strong as the man, the way you may defend yourself may involve a bit of planning, so that's a bit hard to rely on self-defence. And provocation women tended to be the victims. So that was one area that we worked on, and we made a whole lot of recommendations which became part of the criminal law.
And so provocation was taken
abolished.
away as a defence?
Yeah, it was abolished. I had initially thought that there would be circumstances like somebody who's provoked because they're teased about their racial background. I mean, you can imagine that there might be circumstances where somebody is subjected to appalling abuse over a lengthy period of time, say racial abuse. But the cases were not of that kind. I mean, when you actually looked at the cases, they were nearly all family violence type situations. So I changed my mind on that one. But anyway, so those changes were implemented. And the other one we did was the 2004 Sexual Offences Report, and the Victorian Law Reform Commission has since written another report on sexual offences law and practice, but we initiated a whole range of different things which I think were very important. For example, the move towards specialisation in prosecution, specialisation of police, specialisation of prosecutors, which sadly no longer occurs, and some specialist court listing. They were some good things. The child witness service, which meant that a child didn't have to go into court and give their evidence, could go to the child witness service, had their evidence pre-recorded. A lot of those reforms came out of the 2004 Sex Offences Report, and a lot of them have been, I think, pretty successful. I mean, I'm not saying anything is perfect. There's still more needs to be done, but there have been improvements.
After that period, as I said before, Marcia, you do get around. You are appointed to the Victorian Supreme Court.
Have a low boredom threshold, perhaps.
You are appointed to the Supreme Court of Victoria as an appellate justice.
Yes.
To my reading of your background, your legal background, you've had little or no court experience?
That's right.
Was it daunting to sit up there with a wig and gown on and...
It was very daunting. And in fact, some of the ceremonial aspects were particularly daunting because I wasn't familiar with them and I was terrified I was going to commit some solecism. Mind you, that happens to barristers too often. I won't tell you who, but one of my colleagues had a sign in front of him on the bench saying, "Don't stand," because, of course, if you're a barrister, when the judge comes in, you stand up.
So, Marcia, after this extensive career as an academic, as a commissioner, you're now on the Supreme Court of Victoria, in the Court of Appeal. Was being a judge what you expected it to be? What did you expect it to be?
Well, I suppose what I expected, and I knew that I wasn't equipped to be a trial judge, or I could have been, but it would have taken a lot of work, and I might not have been a good trial judge. I thought, there's two things I can do. I'm good at sort of listening and writing and digesting legal principles and setting them out clearly. So from that point of view, I wasn't so concerned. I was concerned about some of the sort of ceremonial aspects. When I got into my chambers on the first day and I had a new associate and she and I both sort of, who's now Silk, I should say, she and I sort of worked out how to robe me because I didn't know what to do. So all of those things were a bit nervous-making, but I had some really supportive and kind mentors. Everyone was kind to me. Chief Justice Marilyn Warren, Justice Maxwell. I had David Harper, who was a trial judge, as a mentor, and some of the county court judges reached out to me too. So they were pretty supportive, I felt, and so I enjoyed it. But the frustration for me, I think, sometimes was, well, the law is the law. You can't change it if it's absolutely clear, but it should be changed. And so that's where my sort of interest in policy came in. Now and then you can say something in a judgment about how it would be a good idea to fix something up, but you can't do that all the time. You've got to be careful about that.
I asked if you were daunted, but probably didn't need to because you offered to write the judgment in the very first appeal you sat on.
I did. That was because I thought, well, I better do it. I think it was a sentencing appeal, and Justice Vincent, who is another lovely mentor and supporter, I went to him and I said, look, I want to get my feet into the water so I'm not frightened. Can I write a draft and show it? I'll volunteer to write this draft and show it to you. So I did, and I showed it to him, and there were a couple of little linguistic changes he made, nothing of any enormous significance. So that was good because that was, if you're a bit scared of doing something, you jump into the water and do it, I think.
Were you given any training in judgeship?
Well, apart from there was a little bit of, I went to the National Judicial College Judicial Orientation Program, and I had been a bit involved in the proposals to set up a Judicial College of Victoria, and I think that judicial education is absolutely vital. I think probably as a trial judge, you may need it even more than an appellate judge, but maybe that's wrong. I'm not sure about that. But certainly I like the idea that you give people judicial training, which is not just about the law, but about the context in which the law sits. And I think that the Judicial College of Victoria has done that pretty well.
You've done a lot of writing. You wrote as an academic. You've written reports from royal commissions and inquiries. You're now doing judicial writing. I think you had a course on judicial writing from Helen Garner, one of our outstanding...
Right. And that was a Judicial College of Victoria exercise. That was terrific, yeah.
Are all these styles of writing the same?
No, and in fact I would say that I've learnt to write probably at least 3 different ways. I remember when I went to the New South Wales Law Reform Commission and I was writing like an academic, and I remember Ron saying to me, you need to do X, Y and Z. I mean, simple things like, dot-pointed paragraphs and breaking things down. So I learnt to write in a more of a law reform style, and then of course you go back to the court and you write in a different style again. But you can learn things from each area. I think learning to write as a law reformer probably helped me with judicial writing as well.
Did you enjoy your time on the bench?
Yes, I did. I enjoyed it a lot. And as I said, I had very nice colleagues, very supportive colleagues. The work was interesting. Yes, so I did enjoy it.
So how did it come about then in 2015 that you were appointed Royal Commissioner into Family Violence?
Well, my term at the court had expired. I was working as an acting judge, and as you would know, when people reach statutory senility, they can go on working as an acting judge. And in fact, I was working full-time as an acting judge. That was the Chief Justice facilitated that. And I was approached and asked if I was interested in this, would be interested. And see, I'd done the part-time commissioner the commissioner in charge of the family violence reference at the VLRC a long time previously. I was on the commission at the time, but I wasn't doing the primary work, so I'd encountered it in that context. I'd encountered issues around family violence in a whole range of other contexts. So I thought it would be interesting. And one of the things I'm particularly interested in, what are often called in sociological literature wicked problems. And a wicked problem is not a moral judgment. It's about a problem which has multifarious causes and things that interact together that are complex. And people often think there's a simple solution. This is how you fix whatever it might be. And I was interested in that notion of how you get different parts of systems to work together. So the Family Violence Royal Commission wasn't just about the law, it was about practice and procedure and support systems. And so we had to hear from all of those people who are involved in those issues. We didn't do what has been done in some royal commissions, call lots of victims. We called some. But I had a wonderful team. I had a wonderful CEO. I couldn't have done it on my own. Everyone had lots of really terrific ideas. So we did a lot of brainstorming and thinking through these ideas and testing propositions. And I had, of course, 2 other commissioners, one of whom was from the Brotherhood of St Lawrence, so he knew all about issues like housing, and one of whom, she had been head of the Department of Community Services, so she had expertise from that point of view, and she had economics experience. So we worked as a team, and I worked as a team with the research staff, because I was the only full-time commissioner, the other 2 were part-time.
The Commission made 227 recommendations. Yes. When we look at the daily headlines about family violence in our community,
yes.
Have those recommendations been carried out? And if so, have they been beneficial?
Well, one of the things that we did do was recommend the appointment of an implementation monitor. And the job of the implementation monitor was to oversee how the government went about its implementation. I think that was very valuable. That was an idea that I copied from Justice Teague in the bushfire inquiry. And there have been a number of reports very careful reports by successive implementation monitors about what's working and what's not. I think I'd make comments on three things. The first is that, and I predicted this, is that there would be more family violence during COVID because people were sort of locked up together in circumstances where you couldn't sort of go out, escape your partner, and under a lot of strain, often under a lot of financial strain. So I think that contributed. Secondly, I think there's now much greater consciousness of the issue, and that increased consciousness has probably it has led to an increase in reporting. So it may be that we're seeing a lot of things that happened in the past that were not reported are now reported and people seek help. And the third comment is state governments are pushed for resources. During COVID, of course, huge amounts of resourcing went into the health system, and it means that the services which are meant to provide support often can only focus on the crisis response. So if you really want to help people escape a family violence situation and stay out of it and recover from what has been done to them, you really need to have longer term support, and it's a problem of resources. It's not peculiar to Victoria, it's right across the country. But we know, for instance, now we're counting women who die in the context of family violence, and that's fairly new. And so we know that there are more women. Well, there are certainly a significant number of women who are dying. It has gone up and down, but I do think that the changes that have been made have made the law fairer, more rational, have protected women, but we've still got a huge way to go.
Certainly seems that. You made the comment that you were shocked. There were many women saying they wish they'd been hit.
Yes.
So people understood.
That's right. And a lot of women didn't and still don't understand the nature of behaviour, which can be intensely controlling and appalling, and yet doesn't include physical violence. And one example that I think of, control of complete financial control, where a woman who's working has to give her wages to her husband who doesn't allow her any money, is an example. But one of the really appalling ones I remember was of a man who used to, obviously a very insecure man who needed help himself, used to drive to work in his car with his wife and children, I can't remember how many children, in the car, and they were made to wait in the car all night while he was at work because he had to control every movement, every breath she took, really. And, what do we do about that? How do we help people to stop doing those sorts of things and to understand the effects that they have, and particularly the effects on their children? Because one of the things we focused on, we didn't just look at violence against women, we looked at all forms of family violence, but we looked at the effects of violence on children. And again, I remember anecdotes like a woman who said to me, well, I finally left after a very, very long time. One of my teenage sons is absolutely furious with me because I left his father, and the other one's absolutely furious with me because I didn't leave 10 years earlier.
You can't win.
You can't win. Very difficult.
Very, very difficult.
And I should, some men are victims of family violence too, much fewer, much lower proportion, so I shouldn't give the impression that it's only about men assaulting or controlling women.
But it would be 9 women to 1 man or 99 women to 1 man.
Yeah, it's certainly disproportionate.
Is there are you optimistic that things are getting better?
Yes, I am, but I think we have to be very careful to look at all of the complex factors that contribute. If we just say these are bad men and you put a ankle bracelet on them, that'll cure the problem. It won't. You have to think about how socio-economic disadvantage, how alcohol, how people who become gambling addicted, all of those factors that they've been mentioned in that recent report which has just come out at Commonwealth level, how all of those factors contribute. You have to look at society as a whole and think about what factors contribute to this and what you can do to help people both to escape and recover from family violence, but also how to have a better life so you don't use these mechanisms about the people that you're supposed to love.
Now, the man who's got the bracelet around his ankle, what made him the person he is and what we as a community can do about that.
Yes, exactly.
It's a huge problem, obviously, and it's there's no end in sight.
William and Lonsdale is brought to you by Greens List, one of the leading multidisciplinary barristers lists in Australia. Greens List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
Marcia, you recently chaired, in the last couple of years, chaired the Tasmanian Commission of Inquiry into the Tasmanian Government's response to child sexual abuse in institutional settings. How long did that inquiry last, and have there been some results come out of that inquiry?
Well, it went for a long time. I think it was 2 years, and it was over COVID, and there have been some responses, but they're still working through the recommendations. There were and are some terrible problems in Tasmania in youth detention, a bit like what we've heard about is now currently happening in WA, in youth detention, in schools, in the health system. I mean, there was a paedophile who worked for 19 years in the Launceston General Hospital and throughout other institutions in the community. So we spent a lot of time talking to individuals who had experienced sexual abuse as children in institutions of that kind. And we really came up with a whole series of proposals for system reform, because one of the difficulties is the need to ensure you have systems in place that when this happens, people have somewhere to complain and they get a response, and that people don't go on working in the institution where they've abused one child. So this built on the National Royal Commission on Institutional Child Abuse, but that focused on bodies such as churches. This was focusing on government response. Churches and schools it dealt with. So this is focusing on how the government responded to systemic issues. And Tasmania has all of the mechanisms that we have in other states, like an ombudsman, for example. But those systems really didn't work to make sure that these issues were addressed. I mean, there's a group of young people or people who are in the Ashley Youth Detention Centre who've just succeeded in a huge class action. It would be much cheaper for the Tasmanian government to have better systems in place than to be compensating people after their lives have been ruined. And of course, many of these people go off and they end up. They're the most disadvantaged people often, to start off with, very often First Nations people, because they're overrepresented in the prison system and in youth detention, and they go on to offend later, because if those things have been done to you as a child, you need help and support to overcome its effects.
Can I ask you what might be a personal question? Dealing with these harrowing and quite terrible situations, family violence, sexual abuse, does it impact upon you?
It certainly does, and I think I would have said while I was at the court that I was able to distance it a bit, but I think it does more now. And I mean, I used to like reading detective stories, so I can't read anything that involves cruelty or child abuse. I tend not to watch television programs of that kind. So it certainly has, and it's time I had a rest from it, I think, after I finished involved in finishing this other project that I'm doing.
And this other project is the Australian Law Reform Commission, of which you are Commissioner.
Yes, I'm one of the part-time commissioners, yes.
Okay. So, and what's the task there?
Well, the task is to try and harmonise laws and practices across Australia on sexual violence, and to ensure that the criminal justice system, which includes reporting processes, police, investigation, OPP, courts, operates in a way that's trauma-informed, and that doesn't mean that people come out of a court process saying, well, it's just as bad as being assaulted.
Which is often the case.
Which people often say.
And they often say, women who have been the subject of sexual abuse often don't report.
Very low proportion of people report, yeah.
Or if they do report and then go through the criminal justice system, they come out pretty battered and bruised.
That's right. And the other part of it, which is very interesting, which I'm not doing as much work on, is the alternatives to the criminal justice system. I am doing some work on restorative justice, and the chair, Mordy Bromberg, is doing a lot of work on, civil actions, using mechanisms like sexual harassment and so on, looking at how some of those mechanisms could be used to provide people with alternative remedies to the criminal justice process. I think that Victoria has, and some other states have done some good things in the criminal justice process, and it's improving. You hear good stories as well as bad stories, but we've still got a huge way to go.
In trying to harmonise things across the states and territories, are the various states and territories cooperative? Are people prepared to try to harmonise?
Yes, but I think harmonisation is an inherently difficult process. I mean, years ago the federal government had a committee which were looking at a model criminal code for across Australia. Didn't happen. People get accustomed to the way they do things. They get accustomed to the law that they apply, and sometimes it's hard to get people to think about maybe you do it in a different way. I mean, an example is we've had a Uniform Evidence Act and it shouldn't be called Uniform Evidence Act, really, but an evidence law that applies more or less uniformly across several jurisdictions. But there are a number of states which haven't picked up on that, and that's an area of law which has a profound effect on the criminal justice system. So the Uniform Evidence Law does things like modify the hearsay rule, for example. And some of those rules that I learnt about when I was in law school continue to apply in some jurisdictions. So
the battle goes on.
Yes.
Marcia, it's almost 60 years since you left law school as a student.
That's terrifying.
It does sound a lot, doesn't it?
Yes.
You've filled many, many important roles in that time. I mean, enough, I think, for probably half a dozen people, let alone one. Is there one particular role you've filled or action you've taken or activity you've been involved in or which gives you special satisfaction, stands out in your memory?
Well, I think the policy reforms that I've worked on have been very important. And funnily enough, I think a small but practical, and it's not small, but a practical thing, there's a child witness service which the Law Reform Commission proposed. And of course I was on their board for a little while, but then went to the court. But I think the work that's being done by people in that context is really very important. And the other area, I think I have had an influence on people that I've taught, as I said, a number of whom have been my friends. And I think I'm glad when I see people who feel that they look at the law in not too narrow a way, when they look at how the law operates in practice, and I hope I've contributed to that.
Well, from the vast experience you've had, looking across our system, and I'm saying Australia, I guess, and specifically Victoria, is there a particular issue you think at the moment which we need to address and are not addressing sufficiently, be it family violence, children in the criminal justice? And what about the age of criminal responsibility for children?
Oh, well, yeah. I think it's unfortunate that there's been a bit of stepping back on that. I mean, in the Tasmanian Commission of Inquiry, we recommended that it should be 14. I think inequality, substantive inequality, is probably the issue we need to think about. How do we make sure that all Australians can live a decent life, can feel reasonably comfortable and secure? Now, that's a huge task. Have equal access to things like healthcare, legal system when they need to, social support services. That's, I think, what I think is the big issue. And, of course, some people are working on these issues, but they don't always work. And I find it difficult to live in a society in which some people have vast amounts of money and other people have very little.
Marcia, it's been an absolute pleasure to have you here this morning. Thank you. And you've continued to be an educator for myself and the other people here in the room with you, and no doubt the people who hear you on our podcast. Thank you very much for coming.
Thanks, Michael.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.